Hi, I'm Alan Keyes. Welcome to IMTV. This is Let's Talk America. Today we're going to be talking about a subject in some depth, I hope, that is actually profoundly important for the future of our country. It does reflect some of the fundamental divisions that now exist in our politics. The one that I think is supremely important is that there are certain elements in our politics, particularly, of course, in the Democratic Party, that have essentially abandoned the American understanding of constitutional self-government. We have a lot of them now openly professing what the socialist ideology, some of them verging toward communist totalitarian ideology. And that way of understanding things is pretty open about the kind of government that is required in order to secure the objectives of the totalitarian socialist agenda. And that kind of government is a dictatorship. I think Karl Marx calls it the dictatorship of the proletariat. But whether you're calling it the dictatorship of the proletariat or the party dictatorship or any kind of dictatorship, it is totally at odds with the intention of the American framers. The framers of the Constitution had it particularly in mind to prevent what they called tyranny, which is the consolidation of all government powers in a single individual or branch of government that can then wield dictatorial control. The Constitution was framed precisely in order to avoid that outcome. And that means that we have a lot of folks now who, though they claim still to be, oh, I'm loyal American, I'm loyal, and they take the oath to the Constitution and everything else, their whole ideological agenda, their whole political agenda, actually aims to overthrow constitutional constraints and destroy the form of self-government that we now have. Interestingly enough, as we have discussed before here on the program, one of the main vehicles for that kind of takeover turns out to be the judiciary. And that should come as a great shock to people who understand how the founders thought the judiciary should operate. The tribunals of the judiciary were supposed to reflect, at least to a certain extent, what the founders had learned about the ancient Roman Republic's tribunes. That's where the word tribunal comes from. And what did tribunes do? They had a very special power to intervene in the activity of the executive enforcement of law in order to protect individuals from abuse. So the tribunals of justice in our country were supposed to assure that the Constitution of the United States, spoken in the voice of the people and relying on certain structures in the government to make sure that dictatorship, despotism that ran roughshod over the unalienable rights of individuals would not become characteristic of the United States government. Many, many features, the system of checks and balances and other such things, are aimed at preventing that kind of dictatorship. And yet, it is the prerequisite of the ideological agenda of many people who are now active and prominent in American politics to achieve just that kind of dictatorship. And the judiciary, tragically enough, has become a key vehicle in achieving that objective. Today, we're going to be talking with my good friend, Publius Huldah, about how this has come about, how it in fact compares to what the founders intended, how the justices have gone about subverting, in fact, that intention. And then we'll spend a little time talking about its consequences and what we can do about it. That should be quite an important look at an issue that is now in issue area after issue area and overall for the integrity of the Constitution becoming increasingly critical to the survival of our government of, by, and for the people, which many of these folks think is already a thing of the past. Well, you and I will have to consider whether that thought is correct and whether there's anything we can do about it with the very capable help of Publius Huldah right after we get back from these words. You can watch our international Roku channel at IMTV. Well, I think we need something like IMTV because of what is obviously going on in our society. Look at Facebook, look at Twitter, look at all of the various things, even on television and in the newspapers. There is a general offensive now against Christianity that is leading all of these powerful media barons and techno-geeks. They're all trying to hound Christians out of the public discussion, out of the public discourse. They're trying to force Christian people to aid and abet and repeat things that are obviously against the will of God and that are lies and deceits. We can't do that, obviously. We need to stand forward and speak the truth. And therefore, in this age of persecution, we need to have an outlet that will provide people of Christian conscience and Christian conviction with the courage to stand by the truth and in the face of all those destructive things that are coming against the very most important founding premise of the United States, which is that our rights and our authority as a sovereign people come from Almighty God. See us online at our website, imtv.us. Welcome back to Let's Talk America. I want to give a special welcome to my guest, Publius Huldah, who's joining us today by audio. We're not going to be able to see, but we'll hear her erudite wisdom today in a back and forth that I hope will enlighten a lot of the folks who are watching the program and help you to deal with and think through the challenges that are now very much at the top of our news cycles and events that are determinative, I think, for the future of liberty and self-government in the United States. Publius Huldah, a good friend, but also someone who has written a plethora of articles that show a really deep understanding of the origins of the Constitution, of the original intentions of the founders, and most importantly, why those intentions have been critical to the survival and success of self-government, and now that people are tossing them aside and ignoring them, why they are critical to the great threats that face the future of our constitutional self-government here in the United States. Welcome to the show, Publius. Thank you for coming on.
Thank you for that warm welcome.
Well, it's always a warm welcome because I've been many times instructed by your clear thinking and your willingness to really look seriously at how what is going on these days conflicts with the original intention of the founders. First question for you. Could you take us through a little bit of your thinking about what the judiciary was actually intended to do in the minds of the founders in terms of the structures of our government in the United States, both at the national level but also in the state governments? How did they see the judiciary functioning?
Okay, for the federal government, the main problem with the federal courts is that they've been hearing cases they have no constitutional authority to hear, and everybody goes along with it. Article 3 of the Constitution created the Judicial Branch of the federal government and lists the 10 categories of cases federal courts have authority to hear. If a case doesn't fall within one of those 10 categories, the federal courts can't lawfully hear it. One of the 10 categories of cases federal courts can hear is cases, quote, arising under this Constitution, but they have horribly abused this category. Hamilton says in his commentary in Federalist number 80 that arising under means that a case must concern a provision expressly contained in the Constitution. And the example Hamilton gives is this. Article 1, Section 10 lists powers the states agreed not to exercise. If a state exercises any of those powers and the federal government sues the states, the federal courts have authority to hear the case. The purpose of this category, allowing the federal courts to hear cases arising under the Constitution, is to authorize the judicial branch to enforce the Constitution, not rewrite it. And that's what they've been doing. Abortion, marriage, homosexuality are not expressly contained in the Constitution. So federal courts don't have jurisdiction over those issues for the country at large. Those issues are reserved by the states or the people. But in our brave new world, where the Constitution means what the judges say it means, that's what we were taught in law school, Alan. That's what I was taught 50 years ago in my constitutional law class. The Constitution means what the judges say it means. That's what all the American lawyers have been taught, and they believe it.
Well, can I ask a question?
Sure.
Because when I hear that formulation, and you hear it in various forms, now one of the forms I understand, in a judge's courtroom, right, where the judge personally is responsible for making sure that things proceed according to the substantive due process and the various observances that are supposed to be part of assuring that a trial is conducted in a fair and equitable manner and so forth and so on. I can understand that the judge is going to have to decide what's going to go on in his courtroom, and in that respect, the so-called, quote, law is what the judge says it is. But when it comes to dealing with legislation from Congress or from state legislatures and so forth, how can the law be what the judge says it is? I thought the law would be what the law says it is, and what the legislature that passed it says it is. How can it suddenly devolve on the courts? But that is even more importantly true of the Constitution. It's spoken in the voice of the American people, ratified by the people at large. One would think that the Constitution would then ultimately be a product of what the people of the United States and their common sense of how the government should behave says it is. And so there, too, you're not talking about the judges and justices having some authority to manufacture things. And that's why I've often wondered how one can put up with that particular formulation when it seems to suggest that the judges have some kind of law-making power. Where did that idea even come from?
First of all, the federal courts were created by Article 3. They are merely creatures of the Constitution and are completely subject to its terms. That's the basic principle. But 100 years ago, Charles Evans Hughes, who later became Chief Justice of the United States Supreme Court, said, yes, we have a Constitution, and it means what the judges say it means. So the statists elevated the Supreme Court, changed their status from being a mere creature of the Constitution to a superior authority to the Constitution, so that the Constitution became Play-Doh in the hands of the federal judges, and everybody went along with it.
Well, see, but I think that is to a great extent true, especially in our time. But let's consider, for example, when Hamilton talks about the judiciary in Federalist 78, he actually deals with the subject of judicial review, which has been the rubric under which they claim the power to strike down laws and invent applications of constitutional words and meanings and things of this kind. But he says very clearly in his discussion of that, that when exercising the power of judicial review, the judges are actually supposed to be looking at the Constitution, looking at a law they are asked to apply or that someone is objecting to, right? They look at the terms of the law, and if a provision of the law is in conflict with what's in the Constitution, not with what the judges say, but what the Constitution says, then they must ignore that, because the Constitution takes precedence over the permanent expressed will of the people, takes precedence over the incidentally expressed will of the people in the law. But here's the question. If that applies, we have three equal branches, right?
Yes.
And all three equal branches, the members, the president as an individual, the members of Congress in the Senate and the House, the judges, they all swear to uphold the Constitution, don't they?
Right.
Now, it seems to me that we say they're independent. Isn't that part of the separation of powers, supposedly, that these are co-equal independent branches charged with responsibility for handling the power that is vested in each of the branches, right? The other branches don't control that power, they do. Yes or no? I think Yes, go ahead.
that
Sorry.
the members of each branch take an oath to obey the Constitution, not to obey the other branches.
That's it. And Hamilton
Yes.
reaches that conclusion. When he's talking about
Yes.
judicial review, he says that they can disregard certain portions or provisions in a law because they conflict with the Constitution, but that doesn't mean that the judges are superior to the other branches. It means that
No.
the Constitution is superior to all the branches. Yes?
The Constitution is superior to Congress.
Right,
And
superior
that's
to-
why that's why the federal courts have authority, the duty to declare an act of Congress which violates the Constitution unconstitutional.
Yes, but
that
let me-
is the federal.
Let me raise a question. I'm President of the United States, right? I'm in charge of the executive.
Yes.
If I read a Supreme Court opinion that is blatantly against what the Constitution actually says, right?
Yes.
Am I obliged to enforce that in spite of the words of the Constitution, or am I obliged to obey the Constitution?
It is your sacred duty imposed by your oath of office to preserve, protect, and defend the Constitution of the United States, to refuse to submit to refuse to enforce any decision of any federal court which you, in the exercise of your own independent judgment, deem to be unconstitutional.
See, that last point, I think, is really critical. The exercise of your independent judgment. That means
Yes.
that each of the branches, one individual over here who is vested with the executive power, the number of persons who are vested with the supreme judicial power, and the number of persons much larger who are invested with the legislative power. But as branches, each one then has to reach a conscientious decision about whether what is before them is consistent with the Constitution, and then
Right.
accept to do what the Constitution allows and refuse to do what the Constitution forbids. Is that right?
Precisely. Each
But how do you
branch of the
how do you
federal-
get from that to judicial supremacy?
It was a doctrine which was fabricated by statists, and everybody went along with it because people don't think. They go with what they're told.
Doesn't it seem then that one of the things that we're confronted with right now is that for various reasons, probably because in certain instances the courts were relieving them of political hot potatoes, right?
Yes.
And they sort of felt, let the court get rid of that one for us so we don't have to answer it because it runs athwart what will hold our particular political empire together. So they let the court take the blame, right? And they think that they're doing something. But if they're actually setting things up so that the court can arrogate to itself a superiority, a supremacy over the understanding of the Constitution, doesn't that in effect establish a judicial despotism, a judicial dictatorship?
Yes, but only because everybody has permitted it to happen.
Right.
The checks and balances, each branch of the federal government has a check on the other branches. But the legislative branch, the legislative branch's check on the federal courts is to impeach them and remove them from the bench. Hamilton points this out in Federalist number 81 at the 8th paragraph. That's Congress's check on the federal courts. The president's check on the federal courts is to refuse to enforce their judgments.
Right.
Hamilton points this out in Federalist number 78. The problem is that nobody knows about the other the checks that the legislative and executive branches have on the federal courts. We weren't taught that in law school. Nobody talks about that anymore.
Well, see, I guess I was kind of taught it when I was studying the theory of the Constitution, and it has shocked me the extent to which it is totally ignored. But I also think it has had devastating effects on the ability now to maintain the constitutional balances in such a way that we can perpetuate this form of government. Because what's essentially happening is that one of the branches is constructing an overpowering tyranny, and that branch happens to be susceptible to the influence and control of what I call an elitist faction in the country. People who actually are seeking to control the government without regard to the participation, vote, and other elements of responsibility that the people of the United States are supposed to have. Doesn't that essentially mean that the Constitution is being systematically overthrown?
Oh, yes. But it's still legally in place. A repentant people could stand up and reclaim it.
Now, let me talk about one circumstance. And if you'll be patient with me for a moment, let me walk through this, because it's a question that I've often wondered about, and it's a little bit of a quibble, I suppose, but it's one of those quibbles that I think has an enormous impact on several aspects of the ability of our government to conduct itself as the founders would have expected. If I ask you, with respect to the national government, in the House and the Senate, what majorities are required to impeach a civil officer of the United States? In the House, what kind of a majority is required to impeach, for example?
You have addressed this in one of your articles, which was very interesting. I meant to look it up in the Madison's Journal of the Federal Convention to see if I could find some insight. You mentioned that it's only when the president is being tried that a two-thirds majority is required, but for everyone else, a simple majority suffices. Right. And that's a very interesting point. I don't know.
Well, see, when I look at the Constitution, I have the bad habit of reading it as it's written. Yeah. And then trying to figure out, okay, forget everything else, read this couple of sentences as they are written, what do they say? In the case of the House of Representatives, it's very clear that a simple majority is required to impeach. Yes? When you get to the business of actually convicting and removing a civil officer, a president, and so forth, the two-thirds majority that most people assume is needed in the Senate to kick anybody out, right? To actually remove anybody, they're saying that a two-thirds majority is required. But where that two-thirds majority enters the picture is very specifically in a clause that relates to when the president is being tried. It is the same, it is a sentence that is part of the same provision that begins, when the president is being tried, the Chief Justice shall preside. Yes? That's very clear.
Yes.
Then there's a colon. And following the colon, it says, and no person shall be convicted but with a two-thirds majority. So in the Senate, a two-thirds majority is required to convict someone when the president is being tried. Because what a colon does is relate the second sentence to the first sentence. But they pretend that that second sentence relates to everything that is mentioned in the whole provision that is made for impeachment of civil officers, including the justices. And I think that that has proved to be a very crippling understanding of the Constitution, because, and yet I'm not at all sure it's the one that prevailed, for instance, during the 19th century. People always comment that it used to be the case before the Civil Service Acts, that when an election occurred, if one party controlled both houses, right, and a president was then elected, there was a clean sweep. They asked everybody to leave and they replaced them, right? And the only people who got to stay were the people who were once again explicitly reconfirmed or reapproved or whatever. But wouldn't that actually be a logical consequence if you got the majorities that were necessary in order to deal with the regular civil officers and the justices of the Supreme Court and so forth, that you would be able to clean house if only a majority was required in both houses? That should have been the case all along, and they assumed in the 19th century that it was. Everybody assumed. If they win to both houses and they have that kind of clout and they have the presidency, then we all have to go if they asked us to go, and they tell us to go. And it was assumed that they would. Now, we have with the Civil Service Acts and all of that, an assumption, okay, they have some protections, but what they don't have is any supervision, because everybody knows it's very hard, usually, to conceive of getting a 2/3 majority. Could you get it in regular cases, especially in a highly partisan environment? I think that has basically crippled what was supposed to be a routine congressional oversight of the other branches. And it's one of the reasons I believe that the justices have been allowed to get out of control, because they no longer feel threatened by impeachment when their judgments fly in the face of the common sense of the public about what the Constitution means and what its consequences ought to be. Does that make sense?
Yes. I would want to read what the framers said to be sure. But I see the logic.
Well, I hope at some point you will take a careful look at that, because I think that's one of the elements that has allowed the judiciary to assert itself against rationality. But it's also contributed to an environment where everybody assumes that somehow or another they have control over the Constitution, even though in effect, as Hamilton argues in 78, he makes it very clear that the justices, as he put it, have neither force nor will, but only judgment.
Only judgment.
And if they have only judgment, their opinion is just that, their opinion. Until the executive joins in to enforce it, it doesn't have the force of law. So why would we call it law?
That's what we were taught in law school.
Law without enforcement is not law. That principle has been clear even in ancient times. People understood if there's no power of enforcement to back it up, written law is just an expression of a good intention or bad intention, as the case may be, on a piece of paper or on a piece of parchment or engraved in a marble slab. And as a result, if you separate that enforcement power from the judiciary, which our system does, they rely on the president for enforcement, as you just said. But everybody seems to forget that. They think that somehow or another the president must automatically obey the court. But if that were the case, wouldn't the courts be supreme?
Yeah.
See, I think a lot of what we assume seems to me to make no sense at all, especially in terms of the judiciary's relationship with the executive, which strikes me as particularly critical because years ago when I was reading in Montesquieu's Spirit of the Laws, I realized that the discussion he has about the separation of powers, and the founders referred to and worked with his understanding of what that separation of powers was about, why it was required that you should have this division of the different powers of government, right? But when he presents the executive power and the powers in the first place, he points out that judgment, the judicial power, is actually an aspect of executive power, which means that that division between the executive and judicial branches is not a natural division. It is a division that is actually a contrivance intended to have a specific purpose in terms of preventing the consolidation of power that most immediately leads to abuse.
And to provide checks and balances, the executive check on the power of the judicial branch.
And vice versa, a judicial supervision of the use of executive power intended to alert the public, right, to the fact that abuses are taking place. But none of the branches are supposed to have an independent authority to simply strike down laws and change wording in the Constitution. This is an absurd state of affairs that we've allowed to develop.
Right.
And my question is, the next question that's logical is, what can we do about it? Do you have any ideas of what are the imperatives to try to move toward controlling this? Aside from the first step, which I hope this program is part of for people who are watching it, first you got to inform people. Get them to go back and take a look at what's supposed to be the case. That's an essential step. And I thank God for the contributions you have made over the years to helping people get to that point. But once people start to realize, wait a minute, this shouldn't be happening, what kind of actions do you think and what kind of resistance should there be to certain other kinds of actions that will help to begin to restore what ought to be the state of affairs?
Well, I think our basic problem is a moral and intellectual problem. We have abandoned facts and reason and logic, and we just go with what everybody else says. We don't think things through. Our belief system has radically changed from that of our founding days to today. Our framers believed in fixed, transcendent, eternal principles. But with the rise of pragmatism in the 1870s, as a people, we abandoned the concept of fixed, eternal truths and principles. Truth became subjective, a matter of opinion. We also embraced Darwinism. We applied the evolutionary theory to the law. We said that law evolves, and that was the origin of the living, breathing Constitution. That was Darwin's evolutionary principle applied to the Constitution. And so we abandoned the concept of the Constitution as being fixed, locked in concrete principles which everybody has a duty to obey.
Well, but when you say we, Publius, who are you actually talking about? Because it seems to me
the American people.
Well, I don't think it was the American people, though, because if you look at what actually happened in our history, right? Let's take the first big instance would be the Civil War. What motivated a lot of the people who fought in that war, particularly on the northern side, but also on the southern side, both were referring to the understanding that there are unalienable rights that human beings have that are not supposed to be violated. One side was focusing on the right of liberty, and the other side was focusing on the right to life and the right to justice. And when you look at that understanding, wasn't that a reflection of the fundamental premises articulated in the Declaration? We're all created equal, endowed by our Creator with certain unalienable rights.
Oh, yes, but it was in the late 1800s and the early 1900s when we abandoned the concept.
No, we didn't. No, see, I have to beg to differ. I think one needs to be careful, because when we fought in World Wars I and World War II, when we were championing the cause of American freedom in the post-World War II period, nobody abandoned the Declaration. Our presidents quoted it, and they motivated people to believe that what we were doing was right because it conformed to the premises of the Declaration. And the people of this country responded to Martin Luther King's appeal, and he stood solidly when he was talking about the injustice of segregation and so forth. He stood solidly on the premises that articulated the transcendent principles of the Declaration. The only reason I'm saying this is because it seems to me that when it came to engaging the support of the American people, the elites in this society always appealed to transcendent principle because they knew that's what moved the American people. But then when it came to talking about law and how it was to be dealt with, and politics and how it was to be dealt with, then they abandoned transcendent principle in favor of evolution and all this other stuff which you're accurately talking about. But here's the rub. If we give in to the evolutionary dogma, aren't we essentially rejecting the egalitarian premise?
I don't quite understand what you mean.
Because the theory of evolution essentially leads to a conclusion that in reality things depend on the survival of the fittest, on the interplay of objective forces that then leave some on top and some on the bottom. That is not a situation of natural equality, that's a situation of natural inequality.
But when the theory of evolution was applied to law, we abandoned the concept of the Constitution as being a body of fixed, firm principles, and we said that the Constitution evolves.
Yes, but what I'm trying to point out, Publius, what I'm trying to get to.
And the judges are the ones who determine what it means. And
yes,
it has a change.
Wait, but what I'm trying to get to is the fact that, yes, you're absolutely accurate that happened amongst our elites It became a premise of the way they handled powers that were entrusted to them by the people. But that was never a premise accepted by the people of this country. When appeals were made to the people, those appeals were always made on the understanding that was a fundamental premise of justice. One of those premises involved the assertion of equality. But if you allow an elitist faction, an elite group, to control your understanding of right and wrong, justice and injustice, lawful and unlawful, then you don't have an egalitarian result. What you have is a hierarchical dictatorship, which is exactly what's implied in the theory of evolution. Evolutionary theory is exactly in opposition to the understanding of justice and right and its sources that's in the Declaration of Independence. And the American people, their self-government, depends on the Declaration, not on evolutionary theory. If evolutionary theory is correct, whatever forces in a society achieve dominant power, they justly then exercise control over the law. Do you think most people in America agree with that?
I think most people in America don't think.
Right. And so they're not thinking about the fact that what is being allowed to be presented as the basic understanding of American law and justice overthrow what has always been acknowledged to be the fundamental premises of American law and justice, which were stated in the Declaration. And by violating those premises, they actually overthrow the whole form of government the Constitution was meant to establish. You see what I'm saying?
Well, yeah, in the Declaration of Independence, we declared all men are created equal, rights come from God, the purpose of government is to secure the rights God gave us, and when the government fails to do that, we have the right to throw it off and set up a new one.
Right.
Those are our four founding principles, and our Constitution was written to implement those principles. But throughout our history, that purpose of government has been changed. During the Progressive era, they denied that rights come from God. They said, no, rights come from government. And so Congress started passing a whole host of laws, creating a new right to live off plunder, the welfare programs, and the federal courts created a whole host of new rights to kill babies, to homosexual sodomy and homosexual marriage. The progressives said that rights come from government, and the purpose of government is to secure the new rights they say we have.
But those
and
new
the
rights...
American people are just going along with it.
But if the American people go along with that understanding, they are going along with the result that removes them from authority in their society.
Yes, yes, it's tragic, and that's what I've been trying to tell them for 10 years.
I know.
And they don't listen.
But I think that part of what we have to get people to understand, because the bad guys, as I call them, have exploited this throughout my whole lifetime. They know good and well that when the American people have been rallied to support this thing or that thing, they are always rallied with an appeal to equality, an appeal to rights, an appeal to justice. This is how it's been done. The successful movements were always the movements that relied on the Declaration logic. And yet, everything about the way the elitist faction, as I call them, understands the law, everything about the progressive ideas turns out not to be progress in terms of that understanding of justice and right America is founded on. That actually turns the clock back to government based on control by the few.
Yes.
And yet most Americans understand little or nothing about this consequence. They get mesmerized by the words, and they don't realize that the content of the words has changed. And essentially, when they use the word rights, they're talking about the right to do what we tell you. That's right. And when they talk about justice, they mean the dictates of our understanding of how to use this power to get you to do what's going to benefit us.
Yes.
But isn't that the same old understanding that the American Revolution turned upside down in order to establish the country? I mean, human beings have been used to that kind of understanding of government for thousands of years.
Yes.
It's so ironic to me that we are calling progress what actually turns the clock back in a way that utterly erases the unique offer that the American people represented to people to take responsible control of their own society, their own destiny, if they were willing to discipline themselves according to an understanding of justice that actually took account of the good of the whole from the perspective of God. I think that that's why the understanding of the Declaration and of its roots in a way of seeing justice that requires that you adopt and acknowledge the supremacy and authority of a benevolent creator. Yes, not a random chance evolution, but an intelligent provision for the universe that includes the creation of human beings in a way especially singled out to give us that special combination of consciousness, self-consciousness, and choice that is then to put us in a position where we can actually make some determinations about how we are going to pursue God's mandate for right. Does that make sense?
It does.
I mean, I think this is part of what's always fascinated and attracted me about the American way of life. But this whole way of understanding the law seems to have abandoned these premises, even as they're still, when they campaign for all this sexual stuff and so on, the word rights is always in their mouth, and equality. Who talks more about equality than the people who are pushing to establish a government dictatorship over our lives? It's crazy. Yeah. It seems to me to be one of those things I always look at it and I say to myself, how is this happening?
The tragedy is that the Declaration of Independence is easy to understand. For the most part, our Constitution is easy to understand. Any reasonably intelligent person can read the two documents and study them and understand what they say. But too few Americans are willing to make the effort.
Mm-hmm. And so it seems like there may be you remember you were talking a few minutes ago about, we were talking, about the fact that it might be sometimes considered advantageous by the chief executive or by the Congress or a governor for political reasons to put the hot potatoes in the court's hands, right?
Yeah.
Do you think something like that sort of passivity, that desire not to be bothered with it, also accounts for the passivity of the American people as things are being redefined in a way that deprives them of a sovereign role in their society?
I think Americans are addicted to handouts, to the social safety net. I think they willingly sold their heritage for a bowl of porridge. I think that they were corrupted with the handouts and the safety net. They liked being relieved of the responsibility of providing for their own lives and that of their families. American men, with the safety nets and the welfare programs, American men were stripped of their role as the primary providers and protectors of their families. It makes me weep when I see what the statists have done to the American people, but what the American people allowed to be done to them.
Do you see any signs of people awakening from what is essentially a kind of passive stupor about this? I mean, are people starting to care at all about the fact that the society is being transformed in a way that will ultimately eliminate any effective political role for the people at large?
I never used to hear people talking about the Federalist Papers. I never heard about the Federalist Papers in law school. But people are now talking about the Federalist Papers, which is something new. There is some interest in the Constitution, but too often Americans, instead of reading the Constitution, that they make pronouncements just based on what they've heard. For example, people used to fuss at Obama for not having prepared a budget, and they said it's his constitutional duty to prepare a budget. It's not his duty to prepare a budget. That's just what everybody said, and Americans heard it, and they repeat it.
Yes.
What Congress is allowed to appropriate funds for is the enumerated powers. That's all they have authority to spend money on.
Well, do
People
you think
just
that
repeat.
shouldn't it be part of the role of the people we elect to Congress, however? Because I can remember when I was growing up that I remember hearing people talking about the Constitution, talking about various provisions of it, having arguments and debates over it, just as if it were really important. And this was in the legislature, right? And there were people who were champions of a constitutional government. And even when one party controlled the Congress, they would still sometimes be in conflict with the president over whether or not he was staying within the bounds of his constitutional prerogatives. That also arose with busing and other phenomenon about whether the courts were staying within the boundaries of their constitutional prerogatives. There was still a lively sense, but somewhere along the line, Americans, and I think it's what you were just saying, did they become so enmeshed in these programs and handouts and Social Security, this is and that, and now health care, that the whole thing becomes a sort of what I'm getting point of view, so that people are no longer trying to elect people who can help them take responsibility for the preservation of the Constitution?
I think that's a big part of it, of our problem. A moral regeneration of the American people is required.
I believe that's correct. You know that, because that's been one of my main themes of my own participation in politics. You know, I can't believe this, but I just got the signal that we're running out of time.
Oh.
Isn't that amazing? I
It
find this
is?
amazing. And we have made some, you know, I hope that as people listened to us talk, they were really thinking through the implications of what we've been saying and are being moved to start exploring these things. One of the first things I love about what you said is to drive people toward the Federalist Papers. Two books that every American ought to have as preparation for being smart enough to govern themselves. One is the Bible, and the other is the Federalist Papers. I think the Federalist Papers is... Sorry, go ahead.
About that, I have something important to say. I was assigned to read the Federalist Papers when I was an undergraduate in philosophy. I found them very difficult. So I got a yellow legal pad, and I read the Federalist Papers, and after each paragraph, I rewrote what it said in my own words on the legal pad. I did that for all of the papers I was assigned. I sweated to learn those papers.
Right.
You have to sweat to learn stuff. And then after you've sweated for years, you can quote them by memory. But it's not easy.
That's exactly right. But I think more Americans, see, and I have to say, I tell people, and I deeply believe this is true, and it's not just, I don't believe in a lot of these sort of watered-down versions of the Bible. I think that folks who stick to the King James Version, and this is coming from somebody who's, I don't have some denominational commitment to it or anything like that, but I like the King James Version because it's a little difficult to read in the same way the Federalist Papers are. And people steeped in reading that Bible are going to be able to understand the Federalist Papers better because they're used to formulations that don't go easy, that are tailoring themselves to express the thought clearly rather than to make it easier to understand the thought. You see what I'm saying?
Yeah.
And that is harder. It challenges you to think, but if the American people don't think and become more and more passive about their thinking, they can't possibly sustain liberty. How are they going to do it?
That is correct. That is correct. And also, it's a great joy to read, particularly Madison. I love his mind.
Well, his mind had a wonderful, what's the word I'm looking for? He was a man who understood how to think through the tensions without trying to eliminate the tensions.
Yes.
so that you can have thoughts in your mind that see that there are opposing principles that are actually working together to achieve an outcome, and you don't try to pretend that they're not there. That's why I think the system of checks and balances, as it's actually supposed to work, is so hard for some Americans to grasp. But we need to talk about this a whole lot more, because I think that, that we've on this program, we've kind of introduced people a little bit to this concept. But I'd like to continue it. And I think you're slated to come back with me on another program where we're going to be dealing with this in a specific context, that it may be helpful to see people, for people to see us trying to work this out in a specific context of how the system of checks and balances and the whole idea of independent branches is working itself out now in the context of an ideological warfare in which one side essentially seeks to abandon the basic premise of limited government that the Constitution was actually intended to establish. And we can even talk about what that concept of limited government really means. But we'll have to do it on our next get-together. Are you fine with that?
I am fine. Yes.
Well, I always appreciate the chance to have this discussion with you, Publius, because part of what I hope we'll be able to do on this show, and I try to do it with all my guests, is give people an example of the thinking that's required. Do you see what I'm saying?
Yeah.
Because I think if people don't refamiliarize themselves with the thought process, then they're not going to start practicing it. They've been invited by MTV approaches and all of this 60-second spot junk and the poking and prodding and name-calling that now substitutes for civil discourse in this country. They've been invited to suspend thinking rather than engage in thinking as they're acquitting their citizen responsibilities. And I think that's part of what is allowing this elitist faction to just, by leaps and bounds, overthrow the Constitution, take over government powers, and take us back to ages when the people really counted for nothing in shaping the destiny of their own society, and we may be returning to that. Let me thank you again for the wonderful contributions you keep making every day to this process. And I hope that in the work we can do together here, we can inspire other people to engage in the kind of wrestling with the fundamental premises, the thinking processes, and finally, get to the point where they can really begin to critique these bad outcomes that are being foisted off as somehow in the service of equality and rights when they're destroying the very concepts that they claim to be serving. It's kind of sad. Thank you again for being on the show.
My
I really
pleasure.
appreciate it. And I hope that y'all out there are appreciating the fact that on IMTV, and you've noticed it again today, what always happens as we are wrestling with these things? We get back to the fact that one of the fundamental roots of difficulty is that we're looking away from the fundamental premise, which is there is a transcendent authority. There are premises and principles that actually should govern the forces that we deal with as human beings, even when those forces are the forces of our own ambition, our own greed, our own aspirations. They are to be governed by a sense of order, a sense of right, so that in dealing with these problems of law, we're actually dealing with something that transcends, right, the forces that are at work. And we have a responsibility to understand that it is part of the intention of the Creator that those forces should be brought under the control of those who are confronted with the choice between right and wrong, and for the sake of God, make the choice for right. And I do believe one of the things that gives me hope about the American people and about their capacity to work this through is what I was trying to point out in the course of the program here. The elitists have their understanding which has abandoned God and right. And yet when they have appealed to the people of this country, when they have appealed to us to do work in the context of what constitutes justice, to do work in the context of what constitutes our role in the world of promoting and defending right and rights for ourselves and other people, what sustained the American people in their commitment, whether it's the Civil War, the Great World Wars, or even the appeals that have been made for certain kinds of social changes, some of which, by the way, are actually detrimental to our liberty, but they've always been couched in terms of an American's desire to see justice done in the sense that the Declaration articulates that justice. Justice done according to a standard that is not just a standard of power or human whim or human greed, passion, and other energetic impulses. It is a standard that, standing apart from all of that, seeks to achieve a relationship, an ordered relationship, in the way that all things function, which I believe corresponds to that phrase in the Bible that says that in God's intention, all things work together for good for those who love him. And I think that that's been a very important part of the motivation of the American people and the appeals that are made, very often with success, to their sense of justice. I think now we desperately need an appeal to that sense of justice and right in order to preserve the whole way of life, the whole constitutional system that allows good-hearted people to play a role they had never played before in human history. A role that was always arrogated to the most successful powers, who came to be the most successful powers, not because they respected justice, but because without conscience they were ruthlessly willing to pursue those goals of their passions. We are a people, therefore, who is distinguished from all of that by our capacity to deliberate and to accept as a result of those deliberations the constraints that justice and right require. And I hope that these discussions will help to reintroduce all of that and help to begin again the kind of discussions that are disciplined by that desire to perpetuate an understanding of law and government and right that respects the constraints, the bonds and boundaries in order to serve the liberty. Because that's what I think our Constitution was all about, in respect of government, but also in respect of the people who are governed. Hope this discussion was useful to you this evening. That's it here for Let's Talk America. I hope you will join us again next time as we delve again from all the different perspectives that the issues present to us. We try to address the challenge of preserving this land, a republic that is both just and free.